Cantu stepped up. They were formulated and their products are better than ever. Welcome to the new Cantu.
Opening new stores is our best customer acquisition tool, and Square's been what's made that
presiding court will not come to order.
All right, ladies and gentlemen, please be seated. Hi, good morning. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. On 22 SC 183572. Let me go ahead and take roll for the morning. Mr. Stilwell and Mr. Sharp, good morning. Good morning. Mr. Williams, Mr. Steele, Mr. Adams, and Mr. Monsbach, good morning, and Ms. Haltwinger, good morning. All right. Okay, Mr. Kendrick and Ms. Hingerty. How's Mr. Weinstein? Okay, all right, okay. All right. Mr. Huey and Mr. Matthews, Jr. and Senior, good morning, gentlemen. Good morning. All right, Mr. Nichols and Mr. Harvey and Ms. Westmoreland, good morning. And Mr. Ryan and Misty Williams, good morning. All right. Mr. Atkins and Ms. Hilton and Ms. Knight, good morning. Good morning. All right. I missed anybody? Okay, all right. Okay, first order of business the court needs to take up this morning. I have two motions to recuse, one filed by defendant Jeffery Williams that was filed yesterday and handed to the court at the end of the business day. Another one has been filed under the same indictment, this indictment 22 SC 183572. And I want to say that that motion to recuse has been filed on behalf of Ms. Kayla Bumpus. Can I get the lawyers for, or the principal lawyer for that particular case to identify themselves for purpose of the record?
Judge, good morning. Gabe Banks.
Good morning, Mr. Banks.
Her legal team is also here. Mr. Collins, Mr. Obey, Mr. Mormon, and Mr. Winchester.
All right, good morning, counsels. Okay, as it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you, okay? So that's how we got here with this. Or else, did you all attempt to send me independently a copy of that, or?
We did not, Judge.
Okay, no harm, no foul, no. So, no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall set fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. In applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else, and that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted, and that is Dacker versus the state, 300 Georgia, 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion, but if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, I mean, the appellate court will review my ruling for, for abuse of discretion.
Certainly
Okay.
understand that, Judge. And stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. So we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time,
Sure.
Other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady. And for that, and I will do that. And then so if that pertains, or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record. Okay.
All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you, because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that's that would be an established fact at the hearing. We also.
But I can't take it. It's not something that I can argue with you at this point in time.
And I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You've made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others, and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not going to, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're going to have to put those in some other pleading. But at this point, Ms. Weaver is going to prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right. Okay. All right. Let's turn now to the statements or interviews from January.
Not to interrupt the court, that finishes our business today, man.
You don't want to stick around?
No.
Okay. Well, okay. Thank you, Mr. Banks. At all. Okay. All right. Okay. Yes, you may be excused, sir. All right, Ms. Hilton and counsels, what matters do you have to take up from the interview from the January 28th, 2015 interview?
Your Honor, last night we sent over both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then the January 28th, probably around 11:30. We have not heard from defense counsel yet, so I'm not sure if they've reviewed them and if they have any additions or disagreement. So we were just waiting for defense counsel to let us know their position.
Okay. Counsels for defendants, have you identified, since now the state has sent you parts from the 28th January interview that you wish for us to talk about? Mr. Sharp?
Good morning, Your Honor. I have not had a chance to digest their proposed redactions. I'm happy to talk to them about it. I've been working feverishly on getting together the redactions that we believe are warranted. Again, I'd be happy to talk to the state about that. I'd also be happy to go through them one by one with the court. However, is favored, but I can't say at this moment that we've cross-referenced the two lists.
Okay, all right, so that's what we're supposed to do this morning, though. So does anybody else have flagged or wish to be heard on the interview for January the 28th? Sure. We're going to cover them independently. Like the January 28th, we'll cover the February 21st, and then we'll cover the June the 10th interview, and then potentially the jail calls.
I believe that myself and Attorney Steele may both have lists. I don't
May have what? Sorry, I'm sorry.
Lists.
Okay.
But we're representing different individuals, so the list may vary a little bit. So you may be getting some suggestions from this chair, some suggestions from that chair, and then some suggestions from the state.
I understand.
Yeah. Okay. Your Honor, may we have 15 minutes to just talk to the state about their list?
Yeah. And does anybody else have any statements that they've identified from the January 28th or February 21st or June 10th, other than Mr. Steele or Mr. Sharp, that they want to bring up? All right. Okay. All right, then I'll give you all 15 minutes, and you can come back, and we can just begin with the 28th of January interviews. Okay. All right. Wes.
Success Vision is now in St. Louis.
Success Vision is my favorite place to get glasses in St. Louis.
flavor. Saucy spoon baked beans.
Since safety is always top of mind for us, having Grainger as a partner, they make it very easy for us.
No.
Okay, all right, okay, all right. How much longer we all need?
Well, I think that Mr. Sharp just represented that they have had an opportunity to identify or to review the redactions. I'll let him speak for himself.
All right, sir.
Not quite what I said. We've identified things that we think need to be redacted. The problem, the mountain we're climbing is both sides have their own transcript, and the pages are not the same. So we're working off two different transcripts, and we have converted our files to MP3. They're still going off the evidence reviewer. So we're working off two different transcripts and two different videos with different timestamps. So we've figured out a system to try to make it work. It's just a little bit time consuming. So we're working on it. We have identified, and we're going to get to the state what our proposed redactions are, and we still have to cross-reference their redactions. So it's just a time-consuming process.
Okay.
We're working as quickly as we can.
If they have redactions that they have identified at this point and they would like to turn them over so we can review them, and if they turn over both the transcript that they are using and the MP3 file that they are using, that corresponds with the redactions that they've requested, we could review those. We could at least be reviewing those while they're correlating the ones we've given them to the media that they have and the transcript that they have, so that the downtime isn't a total wash, and we'll be able to make some kind of progress.
All right. Sure.
I will see if we have we should have a copy of the MP3s. I don't think we have a problem with that, but we'll figure out a way to get them the information so they can reference their materials so they can see what we're suggesting.
Okay.
And we can literally listen to it in their media format, however they give it to us, and we can know whether we agree or disagree with it in the format that they have it right now.
Okay. So how much longer we all need?
Well, we are nearing the end of the January 28th statement. I don't anticipate the February 21st will take us quite as long. I anticipate the June 10th will be very lengthy. So if you're asking to address those two statements, I think that we could be ready in probably 45 minutes to an hour. But regarding June 10th.
Okay, well, let's just bifurcate it. As you all told me before, the June 10th one will take the longest. So, but you have identified most of those statements. Is that correct?
In June 10th?
Yes.
Yes.
Okay. All right.
And the good news about June 10th is we're actually working off the same transcript on that one.
Okay. All right. So do you all want me to give you another 45 minutes? Let's say we recess and have come back at 12:45?
So we'll be discussing which ones will we be discussing?
January 28th and February
21st. At a minimum.
Okay.
Yeah, I'll have to. We'll take up the June 10th one. I had planned on, once we kind of finish those two, we can kind of get an idea what would be an appropriate schedule. Okay.
Yes, sir.
All right. That work for everybody else?
Yes, it does.
Okay. All right. All right. We'll see you all back at 12:45. Okay. Yes, sir. All right. Okay. We're in recess.